Normally, if you're charged with DUI here in California, it's only a misdemeanor. And oftentimes on a first offense, there's no jail time at all. But if you're under the influence and you cause an accident in which a third party is injured, then you can be charged with felony DUI with injury under Vehicle Code Section 23153. And this crime, it's really a wobbler, which means it could be filed as a misdemeanor or a felony, depending on the circumstances. But if it's filed as a felony, you could be sent to prison for up to 4 years, and sometimes even more than that if it's a very significant injury that the person suffers. Now, how serious the case is and what the sentence is likely to be really depends on 4 factors in this situation. One is whether you have a prior record, if you have prior DUIs. Secondly, how high your BAC was. Third, how reckless the driving was. So if you're going 100 miles an hour down a suburban street and ran a stop sign or a red light and it was very reckless driving, then it's a lot more serious, obviously. And fourth, the most important factor in determining the seriousness of the case is the extent of injuries to the victim. If the person just suffers some minor soft tissue injury like some bruising or swelling, then it's probably going to be more like a probation case, maybe even a situation where it would be easy to get the charge reduced to a misdemeanor. But if the person suffers a real serious injury, such as broken bones or a concussion or paralysis, in that case, the prosecutor and the judge are going to be looking at it much more like a state prison case where they're going to want the defendant to do a lot of time, sometimes years in California state prison. Now, that said, as serious as these cases are, oftentimes they can be surprisingly difficult for the prosecutor to prove, because the prosecutor really has to prove 2 things. 1, that the person was under the influence, and 2, that he or she is at fault for the accident. And that's not always clear. First of all, in terms of being under the influence, a lot of times the cops will say they got to the scene and that the suspect his speech was slow and he was discoordinated. But a lot of times that can be the result of injuries or shock that the person suffered from being in the accident. And a lot of times we find that there's problems with the blood test, problems with the breath test, mistakes in the officer's DUI investigation, and the prosecutor can't even prove beyond a reasonable doubt that our client was under the influence. But secondly, and something that gets lost on a lot of people, is that the prosecutor has to prove that the defendant is the one who caused the accident or who was at fault for the accident. And say, for example, that I'm driving down the street, middle of the day, and I'm drunk. There's no question. I'm a .20 BAC. And I'm driving through an intersection on a green light, and somebody comes and runs a red light and T-bones me and hits me from the side, and that person suffers major injuries. Well, in that situation, I may be liable for drunk driving, but I'm not liable for DUI with injury because I'm not the one at fault for the accident. Merely the fact that I was intoxicated and involved in an accident does not necessarily mean that I'm the person at fault. And I can tell you from years of doing this, and I spent 5 years as a prosecutor and 9 years now as a defense lawyer, and I've worked on literally about 6,000 or 7,000 DUI cases. And in looking at these DUI with injury cases, when the CHP or the local traffic investigators go and investigate the accident, when they find out somebody was drinking, they almost always point the finger at the person who was drinking. They rush to judgment. They do a sloppy investigation, and they just assume that the person who had been drinking alcohol is at fault. But it's not always the case. When we have one of these cases, we always do an independent accident reconstruction with an independent investigator. And many times we find that the other person was at fault, or maybe both parties were at fault, or maybe it was some third independent factor that happened such that the accident was inevitable, but ultimately our client was not the one at fault. So many times it's difficult for the prosecutor to prove A, that our client was under the influence, and or B, that our client was at fault. So if you're charged with felony DUI with injury, as daunted as you may be, as serious as the situation is, there are many things a defense lawyer may be able to do for you. If you're in this situation, we encourage you to call us here at Schaus Law Group. Tell us your story. Let us investigate the case. Many times we're able to get these charges reduced or even dismissed.